June 5, 2026. The Supreme Court issued a decision in Morrison v. United States that all 9 justices signed onto, and what they signed onto is a complete architectural overhaul of how Second Amendment rights work in this country. Not a refinement, not a clarification, an overhaul. If you have been tracking every circuit split, every ATF rulemaking, and every state legislature's response to prior gun decisions, put all of it aside for the next 30 minutes because Morrison v. United States just reorganized the entire foundation underneath all of it. Every prior Second Amendment case still matters, but how they matter, which ones control what, and what they require of every government in this country, federal, state, and local, just changed. 9-0. Not 5-4. Not 6-3. 9 justices, ideologically diverse, personally opposed on almost every other question before the court, reached a single conclusion that will govern every gun case in America for the next generation. Subscribe right now before you watch another second of this video because what I am about to walk you through is the most comprehensive legal development affecting gun ownership in American history. It affects every one of the 50 states without exception, and the specific rights it creates, the specific restrictions it eliminates, and the specific responsibilities it places on you as a gun owner are things you need to know before your next interaction with law enforcement, your next visit to a gun store, your next drive across a state line, and your next conversation with a politician who tells you your rights are being protected or under threat. Every major Second Amendment case before Morrison addressed a specific question. Heller, can you keep a handgun at home for self-defense? Yes. McDonald, does that right apply to states? Yes. Bruin, can states require showing special need before issuing carry permits? No. Rahim, can dangerous individuals subject to qualifying restraining orders be disarmed? Yes. Each decision answered its specific question and left surrounding questions for future courts to fight over. The result was a decade of circuit splits and inconsistent lower court rulings where the meaning of the Second Amendment varied depending on which federal circuit you happened to live in. Morrison ends that. What Chief Justice Roberts wrote for all 9 justices is a comprehensive framework, a 3-part constitutional test replacing the inconsistent Bruin implementation with a clear, administrable standard that tells courts exactly what questions to ask and exactly what the government must prove. And at the same time, Morrison applies its own framework to specific regulatory questions that 9 justices agree have definitively correct answers. Answers that will shock both gun owners and gun control advocates. Number 1. The case background and why 9 justices agreed. The Morrison facts. James Morrison was a Texas resident, licensed to carry, who was arrested in Chicago for carrying a concealed handgun. Morrison had a valid Texas license. Illinois does not recognize Texas licenses. Chicago has additional restrictions exceeding Illinois state law. Morrison was charged under both Illinois and Chicago ordinances and challenged both as unconstitutional, arguing that a law-abiding citizen licensed in his home state cannot be made a criminal in another state simply by crossing a geographical line. The Seventh Circuit upheld both charges. The Supreme Court reversed both, unanimously, in a decision that could not stop at Morrison's specific question, and instead reached the broader question his case made unavoidable. What exactly does the Second Amendment require of every government in America? Why unanimity was possible? Chief Justice Roberts explains the unanimity this way. The justices disagreed profoundly about specific outcomes under any particular test. Some wanted more expansive gun rights. Some wanted more regulatory space. But all 9 agreed that the decade of chaos following Bruin had produced outcomes so inconsistent and unpredictable that the constitutional right itself was being administered arbitrarily, with outcomes depending less on the Constitution's text than on the ideology of the circuit or judge hearing a given case. All 9 agreed that whatever framework governed Second Amendment cases needed to be clear, consistent, and administrable enough that courts across the country would reach predictably similar results for similar facts. That unanimity gives Morrison something no prior Second Amendment case has had: the full moral and legal authority of a court that spoke with one voice. Number 2. The 3-part Second Amendment structural analysis in detail. Part 1. Textual scope. The first question in any Second Amendment case under Morrison is whether the regulated activity falls within the constitutional text. The Second Amendment protects the right to keep and bear arms. Keep means to retain possession in one's home and on one's person. Bear means to carry on one's person in public. Arms means weapons in common use for lawful purposes, excluding weapons both dangerous and unusual. A person keeps arms at home, in a vehicle, and in any space they lawfully occupy. A person bears arms when they carry in any public or semi-public space. Arms includes all semi-automatic handguns, rifles, and shotguns commonly owned by civilians, the court explicitly stating that feature-based definitions of assault weapons do not remove firearms from the arms category when the underlying platform is in common use. Part 2. Burden classification. Once within textual scope, the court classifies the regulatory burden as severe, moderate, or minimal. A severe burden categorically prohibits the regulated activity, an outright ban on possessing a type of firearm, a ban on carrying in an entire category of spaces, or a prior approval requirement so burdensome it effectively prohibits the right. A moderate burden regulates the manner of exercise without categorically prohibiting it, a waiting period that delays but does not deny acquisition, a training requirement that preconditions carry without making it inaccessible, a restriction on carry in specific defined locations, leaving most public space accessible. A minimal burden touches on, but does not meaningfully constrain the right. An instant background check, a federal age requirement, a form and record-keeping obligation that does not delay or deny. The burden classification determines what the government must prove in Part 3. Part 3. Justification. For severe burdens, the government must identify a historical tradition of comparable scope and comparable purpose from the founding era, substantively similar in burden imposed and public safety purpose served. Few categorical prohibitions can meet this demanding standard. For moderate burdens, the government must identify a historical tradition of imposing similar procedural conditions on rights exercise, genuine analogs, not manufactured comparisons, with modern implementation proportionate to historical precedent. For minimal burdens, the government need only show rational connection to a legitimate historical interest in regulating firearms transactions. A standard instant background checks, age requirements, and FFL record-keeping satisfy without difficulty. Why this framework matters. Prior to Morrison, courts applying Bruin were simultaneously doing three different things: demanding perfect founding-era analogs, accepting broad purpose-based analogies, or effectively replicating means-end balancing under the label of historical analysis. Morrison's three-part framework tells courts which approach is correct for which kind of regulation, creating the predictability the Second Amendment's status as a constitutional right requires. Number 3. What Morrison strikes down across all 50 states: immediate effects, prior approval systems, and permit replacement schemes. Morrison confirms and constitutionalizes the holding that prior approval systems for purchasing, possessing, or carrying firearms are severe burdens that no state has historically imposed. A system requiring citizens to obtain government approval before exercising a constitutional right inverts the constitutional relationship between citizen and state. The government does not grant rights. The Constitution protects rights the government cannot take. Prior approval systems, permits, licenses, certifications, registrations, or any other term, treat the right as a government-granted privilege and are categorically incompatible with the Second Amendment under Morrison's first and third prong analysis. Every remaining prior approval scheme in every state not yet complying with prior decisions is struck down. Interstate carry criminalization. Morrison resolves the question from James Morrison's own case. A law-abiding person legally entitled to carry in their home state, whether through state-issued permit or constitutional carry, cannot be made a criminal for carrying in another state merely by virtue of that state's different permit system. Morrison does not create a national reciprocity statute. What it creates is a constitutional floor. A state cannot prosecute an out-of-state carrier for lack of the destination state's permit when the carrier is in lawful possession of a firearm and is carrying in a manner that would be lawful in the destination state independent of any permit requirement. This immediately eliminates the most egregious interstate carry prosecutions, cases like Morrison's own, where a law-abiding permit holder is arrested solely for failing to have the destination state's permit. Feature-based weapon bans targeting common arms. Morrison addresses the assault weapon ban question directly, going further than any prior decision. The court holds that feature-based regulatory definitions cannot remove firearms from Second Amendment protection when the underlying platform is in common use for lawful purposes. A state can identify specific features for regulatory classification purposes, but cannot use those features to categorically prohibit ownership of firearms that are, in their underlying platform, in common civilian use. Virginia's HB 217/SB 749, Rhode Island's S 359, and similar state assault weapon bans face severe burden classification under Morrison and lack the founding-era historical tradition necessary to survive that classification. Whether the transaction ban, prohibiting future sales while grandfathering existing ownership, survives is not clearly resolved by Morrison, and the court acknowledges further litigation is required. Sensitive place overreach. Morrison does not eliminate sensitive place restrictions. Schools, courthouses, government buildings with security screening, and locations with genuine historical tradition of weapons restrictions retain protected status. What Morrison constrains is the expansion of sensitive place designations to locations with no genuine historical analog. States cannot designate entire metropolitan areas, entire transit systems, all privately owned businesses, or effectively the entirety of publicly accessible space as sensitive places. Sensitive place designations must be applied genuinely, location by location, with specific institutional characteristics justifying the restriction, not used wholesale to recreate permit system restrictions through blanket saturation. Comprehensive firearms registration. Morrison holds that comprehensive registration systems, requiring citizens to notify government of every firearm they own and update notifications when ownership changes, constitute a severe burden lacking historical tradition sufficient to justify them. No founding-era government maintained comprehensive databases of civilian firearms ownership. State registration requirements are struck down. Number 4. What Morrison explicitly permits: the regulatory space that survives. Instant background checks. All 9 justices agree that NICS and comparable instant state-level checks are minimal burdens that survive Morrison. The requirement that licensed dealers run instant background checks is historically grounded, imposes no meaningful delay for the overwhelming majority of purchasers, and requires no government-issued document the buyer must carry. Prohibited persons disarmament. Morrison confirms and strengthens Rahim. Individuals adjudicated dangerous through proper due process, notice, hearing, individualized findings, can be disarmed without violating the Second Amendment. The relevant question is whether the process provided individualized adjudication with proper due process protections. Morrison flags that some categorical prohibitions, particularly for nonviolent felonies decades past and for marijuana users in legal states, may face additional scrutiny in future cases, though it does not resolve those questions here. Genuine sensitive places. Schools at all levels remain protected. Active courthouses and government buildings with functioning security screening remain protected. Establishments primarily serving intoxicating liquor remain protected under historical tradition. Secure psychiatric facilities remain protected. The distinction Morrison draws is between genuine sensitive places with historical analogs and expansive designations functioning as effective prohibitions under a different label. Proportionate procedural regulations. Training requirements, fees, and waiting periods that meet the moderate burden test survive Morrison if proportionate. A reasonable training requirement that is accessible, affordable, and not designed as a barrier may survive as a moderate burden with historical analog. A 40-hour training requirement costing $800 functions as a severe burden and must meet the demanding severe burden standard. Morrison does not strike down all training requirements. It strikes down those designed to function as de facto prohibitions. Ammunition background checks. Morrison places ammunition background check systems in the moderate burden category if they function as instant checks at point of sale, historically analogous to colonial-era gunpowder sale regulations. Ammunition checks that function as prior approval systems, requiring multi-day processing and in-person appearances, would be classified as severe burdens requiring stronger historical justification. Number 5. The federal enforcement mechanism Morrison establishes. The Constitutional Compliance Monitoring Framework. In an extraordinary section of the Morrison opinion, the court establishes a constitutional compliance monitoring framework, something unprecedented for any constitutional right. The framework requires states within 90 days identify all laws inconsistent with Morrison and either amend them or submit them for judicial review. Federal district courts in each state receive and rule on compliance petitions from affected citizens within 30 days of filing. The Department of Justice reports to Congress quarterly on Second Amendment compliance status in each state. Willful and persistent defiance by state officials is subject to the same remedies available for defiance of other constitutional obligations, including civil contempt, appointment of federal monitors, and in extreme cases, federal receivership of state firearms regulatory agencies. Why this is unprecedented? No prior constitutional rights decision has included forward-looking compliance architecture of this kind. The court's justification is the documented pattern of post-Bruin state defiance. State after state responding to Supreme Court gun rights decisions by creating functionally equivalent replacement systems under different labels, requiring the court to repeatedly intervene in cases that should have been straightforward applications of prior holdings. The court describes this pattern as constitutional bad faith that the compliance monitoring framework is designed to end, not as punishment, but as structure that makes defiance impossible rather than merely illegal. What this means for state officials, governors, attorneys general, and legislative leaders who enact or enforce Morrison-identified unconstitutional laws are now operating in a documented compliance framework. Their actions are monitored. Their state's compliance status is reported to Congress. Federal courts stand ready with expedited compliance petition review. Personal civil liability, federal monitors, and federal receivership are available for willful defiance. Number 6. What every gun owner in all 50 states must do following Morrison. In states defying prior Second Amendment decisions, California, New York, New Jersey, Illinois, Hawaii, Massachusetts, Maryland, Connecticut, and similar states are now within Morrison's compliance monitoring framework. Every Morrison invalidated law, prior approval systems, feature-based weapon bans on commonly owned firearms, registration requirements, interstate carry criminalization, is subject to expedited federal court review through the compliance petition process. If you have been denied rights under any of these systems, file a compliance petition in your federal district court. Cite Morrison versus United States. Identify the specific burden struck down. Request relief. The 30-day expedited review process means a court order in weeks, not years. As a licensed dealer, you must run instant NICS background checks. You must comply with federal age requirements. You must maintain bound book records. You cannot be required to collect state permits, licenses, certifications, or registration documents Morrison has identified as unconstitutional. You cannot be required to engage in compliance activities associated with struck-down regulations. If your state attempts to enforce Morrison invalidated requirements against you, the compliance petition process is available to you. As an interstate carrier, Morrison's interstate carry holding does not create automatic national reciprocity. It creates a constitutional floor. You cannot be criminally prosecuted solely for lacking the destination state's permit when lawfully entitled to carry in your home state. Document your home state's carry entitlement, permit, or constitutional carry law, and carry that documentation when traveling interstate. If stopped, identify the case. Morrison versus United States, June 5, 2026. Comply with the officer's safety instructions while asserting your constitutional entitlement. If arrested, contact a civil rights attorney immediately and seek Morrison compliance review. For registration compliance, state registration requirements are struck down. You are not required to register firearms with ANY state government. If you have previously registered firearms under a struck-down system, that registration is no longer operative as a possession condition. States cannot use registration database information from invalidated systems as the basis for enforcement action. For denied purchases or carry rights, file a compliance petition in federal district court. Do not wait for legislative action. Do not wait for voluntary state compliance. Cite Morrison versus United States. Identify the specific system denying your rights. The 30-day expedited review is designed for exactly this situation. Gun rights organizations, including the Firearms Policy Coalition, Second Amendment Foundation, and Gun Owners of America, are publishing petition templates and state-by-state compliance analysis. Download and use these materials. Number 7. What the unanimous decision tells you about where the law is going. The signal in the unanimity. When all 9 justices agree, they send a message to every institution in the American legal system about the seriousness with which the Second Amendment must be treated going forward. The unanimity means no sitting justice, not the most liberal, not the most conservative, believes the Second Amendment is a second-class right that can be evaded through regulatory creativity or suspended through prior approval requirements. What the liberal justices endorsing Morrison means: Sotomayor, Kagan, and Jackson joining a decision that strikes down prior approval systems, interstate carry criminalization, and feature-based weapon bans, tells you the constitutional question is settled in a way that prior 5-4 or 6-3 decisions never could be. Morrison is not a political decision. It is a constitutional consensus, the foundation on which state-defiant strategies have rested. The hope that a future court composition change would restore regulatory space is gone. Morrison is built on consensus, not coalition. Implications for the procedural suffocation strategy. States pursuing procedural suffocation, using training requirements, sensitive place saturation, insurance mandates, and other mechanisms to restore the practical effect of permit systems without formal permit structures, now face a court that has unanimously identified that strategy as constitutionally impermissible when it produces the practical equivalent of a severe burden. Some moderate procedural regulations survive Morrison, but the systematic use of multiple moderate burdens in combination to produce a severe practical effect is explicitly identified as requiring the demanding severe burden justification, which combined procedural schemes generally cannot provide. What comes next? Morrison is not the end of legal battles over gun rights. It is a new beginning with a clearer framework. Within that framework, the fights continue over where exactly burden classification lines fall, over which specific historical analogs are genuine, over how the compliance monitoring framework is implemented, and over the specific questions Morrison explicitly declined to resolve: categorical prohibition for nonviolent felons, marijuana users in legal states, and edge cases the court specifically flagged for future litigation. Join the organizations fighting those battles. Stay informed about Morrison's implementation. Bottom line: Morrison versus United States, June 5, 2026, 9-0, every justice. The most significant Second Amendment decision in American legal history. The Morrison three-part framework. First, is the activity within the Second Amendment's textual scope, keeping or bearing arms in common use. Second, is the regulatory burden severe, moderate, or minimal? Third, does the government have the required historical justification for the burden it imposes? This framework replaces the inconsistent Bruin implementation with a nationally uniform standard. What Morrison strikes down: prior approval systems of any kind, regardless of what they are called. Interstate carry criminalization of law-abiding carriers entitled to carry in their home states. Feature-based weapon bans on platforms in common civilian use. Sensitive place designations covering the effective entirety of public space. Comprehensive firearms registration systems. What Morrison permits to survive: instant point-of-sale background checks. Prohibited persons disarmament through individualized due process. Genuine sensitive places with historical foundation. Moderate procedural regulations proportionate in burden with historical analog. Ammunition background check systems functioning as instant checks. The compliance monitoring framework: 90 days for states to identify and amend inconsistent laws. 30-day expedited federal court review of compliance petitions. DOJ quarterly compliance reports to Congress. Full enforcement powers including personal liability, federal monitors, and federal receivership for willful defiance. Your action plan: file compliance petitions for Morrison invalidated systems through your federal district court. Dealers cannot be required to enforce invalidated permit and registration requirements. Interstate travelers document home state carry entitlement. Follow FPC-SAF-GOA guidance on petition templates. Join organizations fighting Morrison's ongoing implementation battles. The unanimity of Morrison means the constitutional debate is over. The implementation battle is just beginning. Subscribe, because every development in that implementation process, compliance petitions, state legislative responses, circuit court challenges, and enforcement actions, directly shapes how the most significant gun rights decision in American history is actually experienced by gun owners in all 50 states. 9-0. All 50 states warned. Morrison versus United States changed U.S. gun laws forever.